Uh, and
It's happening now. It's started.
yeah, it started now.
I'll only request my fellow participants here just to give your ears because a lot of preparation has gone into the session. अगर आप इसको 1 घंटे का सेशन हम अगर अच्छे से सुन लेंगे तो you'll be very poised and calm that okay, I'm aware of what the changes that are coming through. And they're very, very important and far-reaching, impactful changes.
In fact, I extend the saying of Mamta ji, who has been a mentor of mine, that हम लोगों ने जो ये session बनाया, we made this session not as a copy and paste of what has come. We have put our thought in it that why these provisions were necessary and why these provisions have come out to be there, like CIRP. What is the necessity of bringing the CIRP provisions when already CIRP was there? And we use our experience and and our connection with the relevant authorities also, whereby we have taken their input also, that what prompted them to go for these changes and why they want to move forward, reduce this timeline from 180 to 150 days. And because I tell you one thing, in IBC, everybody is aware that delay is causing a lot of harm to the IBC, mainly because of lack of infrastructure. Because every member, every judicial member in NCLT, every officer at IBBI wants that the timeline in the IBB, IBC be met with be met in letter and spirit. But in any case, it happens. Okay, we were having a last meeting at 16th of March, and we generally have one meeting, and now we have a meeting today on 22nd. It's our 87th meeting, and my membership strength is 322. Our association is the 7.5 year young, and perhaps we are one of the association on all of India basis who has been continuously doing all this thing for the last 7.5 years, and hopefully will continue also in the coming years till this thing is IBC is there. Disclaimer, usual my disclaimer, because whatever we say, it's our opinion. IPA has nothing to do with it. Me as an individual has nothing to do with it. If you want to use it as per your wisdom. It's only for education purpose. Okay, discussion paper on CIRP, call it Creditor Initiated Insolvency Resolution Process. When I thought to act on it, thought to take a webinar on it, then first and foremost what come out to be in my mind is that why CRP prison introduced despite 9 year tested CRP framework. I shall request Mamta ji and Mr. Prasad also to enlighten with their experience also. When what I am saying and what I am I am enlightening it. At present, IBC provides the following routes for acceptance of application. Section 7, application by financial creditor. Section 9, application by OC. Section 10, application by CD. Section 59, voluntary liquidation. Financial creditors application, if we go to the historical data, financial creditors application are the highest among all Section 9, 10, 59 applications. Financial creditors application up to December 2025 were 4,211 out of total 8,833, constituting around 58% of total, application. No. This is the worrying factor. Average time taken for resolution is 619 days, excluding admission time, for which no official data is available, but critically average of admission goes around 1 year, resulting in overall timeline of 3 years. That's quite painstaking when we compare it with our 180 days, 270 days, and 330 days maximum timeline. Meaning thereby that a lot of time is consumed in average CIRP process. The adjudicating authority, appellate authority often prefers a settlement under Section 12A, considering the prolonged timelines and many other practical concerns. Financial creditors, mainly banks, have gradually lost confidence in the CRP and are increasingly opting for alternative remedies such as, I divided alternative remedies in three parts. Before filing of CRP, many banks, whatever talk we have with them, they instead of going to the CRP route, they prefer OTS, because of delays and other many processes there. They if they able to feel that their recovery that can be recovered through the pledged asset, they go for the SARFAESI routes. We already have a PPIRP under section 54A to 54P. Then why we are having a need for creditor CIRP under section 58? After filing CRP, withdrawal under section 12A, all the above mechanisms have their own advantages and disadvantages. For example, CRP is time consuming, and in many cases, the existing management may run the company as a going concern better than NRP. This is, I'm not saying out of our experience, but it is an international practice also. For example, in the USA, Chapter 11 filings follow a debtor in possession model, and similar debtor rented systems exist in many other developed countries also. However, over time, creditor-oriented models have also gained acceptance globally. OTS does not provide the benefit of clean slate principle. The clean slate principle is something very, very big in IBC proceedings. SARFAESI generally results in recovery limited to asset value and has no strict timelines. When I tried to knock from the Google how much time they take, I came out that it is on the average 603 days, meaning thereby that around 2 years. PPIRP, PPIRP, they came out with a lot of fanfares, but it did not have any success. Somehow, we feel proud that the first application of Amrit Nira Limited was filed by me as an individual, handling the whole process there. PPIRP limitation is that MSME sector only. It is confined to MSME sector only. You have to give prior declaration of preferential undervalued transactions, which many a times act as a big stumbling block for going for the PPIRP. If you give a haircut to the OC, then you have to go to the public also. Plus, many other prisons are there whereby this PPIRP is get converted into CRP because of very, very small faults of the management. Hence, no management ever want to go for the PPIRP. That is the reason it has lost its shine and it could not be implemented. I hope since CIRP, which is alternative to the PPIRP, or maybe far better place than PPIRP, it will have flying start. Therefore, the MCA IBBI appears to have conceptualized a hybrid model, CIRP, intended to provide the following benefits. I salute to IBBI the kind of hard work which they are putting to, bringing out such innovative changes and accompanied with regulations and all this thing there. Ministry of Corporate Affairs also. And what are the basic things therein? It's a time-bound transition process, 150 days initially, maximum extension of 45 days, 195 days under Section 58D, as against 330 days of the CIRP under Section 12. I hope with the less involvement of the judiciary, because they are heavily occupied, the time when given therein shall be adhered, or at least it shall not reach to 600 or 700 days as is happening in the CRP. Control initially remains with the debtor with provisions of shifting of control to creditors as per section 58E, 58F and 58H. हम इनको थोड़ा सा डिटेल में बाद में पढ़ेंगे, बट सेक्शन 58E is related to mismanagement. 58H describes the procedure की how this CIIRP में से एक आई काट के CIRP में कब कन्वर्ट होगा, and that we shall study later on. Okay, now we have broadly understood about it, and now everybody will be excited to know कि ये चलिए हमने मनोज जी बता तो दिया कि ये अब इसके अंदर आ रहा है, and when we can expect implementation. We as I told earlier that we attended a meeting, IBBI called for a meeting in Delhi, and when we attended that meeting, So they themselves come out with a proposal that there is some day on 30th May, IBBI Formation Day or something like that, which they said we intend that these regulations be made implemented or relevant provisions in the code sections be also placed implemented around 30th May. If it doesn't happen 30th May, you can expect maximum in the middle of June these provisions will be admitted. Legal framework. Now let's understand what legal framework is at present there to do this thing. They have introduced chapter 4A, comprises of section 58A to 58K. I just remind you, in case of PPIRP, they introduced the chapter 3A. With section 54, A to I think J or something like that. They have given 22 draft regulations and 11 new forms. Here, one thing is, one thing I just for the as an academician share with you that although, as I told earlier, they have said that they will notify firms through issue of circulars, but most probably the CIRP process was so intense that they have issued forms in the regulation, and what these forms are, we shall look into it later on. Okay, I just stopped my PPT here. I've just shared with everybody the reasons of initiation of CIRP. I request Mr. Prasad and my highly experienced sister Mamta Benani ji, can they, or even others also, Mr. G.K.V. Karao, very senior insolvency professional, and others also, that what in their mind and in their thought process was of shifting from section 7 to this CIRP under section 58.
Mr. Prasad, if
Yeah,
you're saying yes.
it's only to see that the shortcomings of Section 7 while implementation will be overcome, and this will be more effective according to me. And once we really handle how it is practically being adjudicated upon, then we will be able to understand. And in fact, this is a refined Section 7. That's all.
Okay. Mamta ji, please आप बताइए, and other participants also.
Anuj ji, to all the esteemed participants, they are absolutely to the thick and thin of this. I have felt by seeing this there's a lot of value erosion that happens, when actually an application is filed towards initiation and there's a gap between initiation and admission. That gap will now totally vanish. So, and now the debtors, I feel, will be more wary and will be more careful because now they understand that there will be not so much a court process which will come in the middle to kind of, be acting as sometimes, as it just takes a little bit time before the admission, etc., takes place. So that cushion is now gone. And one must understand that this is in value. जो आप बोल रहे
Yes,
हैं,
51%.
in value.
Yes.
तो बहुत कंफ्यूजन आया था जब CIIRP का बातचीत चालू हुआ. So even if there is one financial creditor in the company, and obviously that will be 100%, so they can also initiate this CIIRP. More than 51% and more होते ही वो initiate कर सकता है. So number is not very big thing. It is the value. So these two are the inputs. And of course, it is a debtor in possession. But as we saw in PPIRP, this CIIRP, if misused by the debtor in possession, can quickly turn into CIRP. So this is another such provision that we need to study.
Yes, Mr. Kapuri, you want to say something? Come forward.
No, sir.
Okay. Anyone else would like to enlighten us on this particular point? What me and Mamta ji and Prasad sir has discussed? Anyone else? Okay. Extending Mamta ji's point, if it was so good and so beneficial, then in my, what I thought of is that it will be confined to as per RBI Section 58, institutions coming under that. Number one. Number two, operational credits has been left out of all this thing there. If that is also a little bit thought process. What I feel is that most probably like PG2CD cases when they amended Section 4, they thought of going for PG2CD initially for corporate debtor to personal control of corporate debtor only, and later on they will move as per Section 2 subsection E clause the 2, 3, 4 to other persons also. Maybe with the success and passage of time of CIRP, authorities may move to other types of creditors also, rather than confining it to the RBI related financial creditors, mainly banks only. Okay, this is what I feel. Maybe now let me move to my slides. And again, I shall request that if yeah, Mr. Gautam Singh, welcome. If you open up your videos, then it will be quite interactive. And if you real लगता है कि we are this is not our webinar, but we are sitting in a seminar. Okay. Now let me move forward. Now let me lighten you. I'm not deep delving into it, not from from advocates' eyes, simply from insolvency professionals' eyes. We should know what these sections broadly are. Because if we try to read it in the given discussion paper or in the given IBC Act, whereby you require a lot of energy and in fact many times pain also when they say this provision is implemented to the change to this section is changed to this. Considering that thing, we have prepared by doing our team and VARs are doing hard work that what these sections are. Let's have a broader look of for these sections. Section 58 prescribes the classes of corporate debtor eligible for CIRP, excludes entities already under CIRP, PPIRP, liquidation, and those having undergone similar processes in the preceding 3 years. अब वो कौन सी क्लासेस ऑफ क्रेडिटर्स हैं when we shall move to the relevant discussion paper, then we shall look into it. Section 58B enables eligibility financial creditors, EFC, which is defined under Regulation 21B, holding not less than 51% in value to commence CIRP after serving prior notice to the corporate debtor and appointing a registration professional with commencement through public announcement. New concept we should remember as an RP, EFC, eligible financial creditor, meaning thereby who holds more than 51% value. Section 58C grants the corporate debtor a right to challenge the commencement before the adjudicating authority within 30 days, where the NCLT may set aside the process or convert it into CRP. My advocate friends can enlighten me. I think if after proposed amendment being made effective, now exceeding Vidarbha, now they have to look only into debt and default. Debt mean 1 crore rupees and default mean non-payment. What ground this CD will have to go to the adjudicating authority for this thing there for the purpose of quashing this particular CIRP process. Only time will tell. And if anybody can enlighten us, he can tell us what particular situations can be there. We can halt therein. And I hope this 30 days shall be mandatory, not directory, respectfully interpretation by my my respected adjudicating authority. प्रसाद सर, आप कुछ कहना चाहेंगे इसके बारे में, सेक्शन 58C के बारे में?
Since now it is built as a part of the regulation, let us get guided by the spirit that it is mandatory only, but not just directory.
Okay. And what Mamta ji and the others can enlighten us, what can be the challenging grounds for CD or its a management to go for it, whereby they can challenge that the CIRP process is not proper.
This you're talking about CIIRP, right?
Yes, exactly.
So
Yes.
they have 30 days time, minimum 30 days time to respond to the person who is
हाँ जी, हाँ जी,
initiating, right?
हाँ जी,
Eligible.
हाँ जी.
So one ground itself is that our contentions were not considered, right? Because after 30 days, it has to again go to the committee to get that 51% share in CIIRP. So if those grounds of objections are not considered, then CIIRP will not start or will be challenged any which ways.
Okay. You want to
The
say
30-day
another
window is
ground be
there.
there that
Within 30
you
days,
know.
and within 30 days, you have to go back to the 51%. Again, you have to get actually. So that has to be taken twice, not once.
Okay. You mean to say that that can also be one of the ground. Okay. Anyone else?
It's like surfacey where they say no that we had objected and the bank did not consider it. And that
Hmm.
itself is a ground to go again in the essay,
Hmm.
securitization application. Similar thing
Hmm.
will happen here also.
Okay.
Yeah.
I never practiced this surface yet because before IBC I was solely a CA practitioner.
आनंद साहब, इसमें ये
हाँ
भी हो
जी,
सकता है कि वो
हाँ बताइए ना प्लीज.
ओटीएस अंडर डिस्कशन है, वी आर नेगोशिएटिंग विद द बैंक, ये
सर
जो
ओटीएस तो ना बैंक को अच्छा लगेगा ना सीडी को अच्छा लगेगा, स्पेशली एमएसएमई में जब उसको एक क्लीन स्लेट का बेनिफिट इसके अंदर मिलेगा. बट स्टिल
नहीं,
दीज
ओटीएस तो
एक्सक्यूजेस.
बैंक के लिए तो ठीक है, लेकिन इसके सीआईआईआर थ्रू अगर वो पूरी इंसॉल्वेंसी रिजॉल्व होता है तो कंप्लीट बेनिफिट है, कंप्लीट ओवरऑल वॉशिंग ही है.
वैसे इसमें ना एक सर आपको मैं एक बड़ी इंटरेस्टिंग सी बात बताना चाहता हूँ. मेरे एक केस के अंदर मैं नाम नहीं लूंगा जिसके अंदर मैं प्रपोज आईआरपी हूँ, दैट्स अ वेरी बिग कंपनी. तो वो ओटीएस के बहाने में सेक्शन और यानी कि एप्लीकेशन नहीं एडमिट होने दे रही फॉर द लास्ट 2 years. तो समटाइम्स हम
वो
सोचते
यहाँ
हैं
तो पॉसिबल हो जाएगा ना, वो यहाँ पॉसिबल.
यहाँ भी यानी कि आपने मुकेश जी बिल्कुल ठीक कहा कि मैनी टाइम्स हम लोग बहुत सारी चीज़ें इन्वेस्ट नहीं करते. और लेकिन वो होता ही है कि जब भी वो ओटीएस की बारी आती है तो क्या कहते हैं, वो एक थोड़ा सा चेक उनको पकड़ा देते हैं, कहते हैं जी हमारी ये
हाँ, आ गया, हमारा डिस्कशन चल रहा है.
हमारी डिस्कशन चल रहा है, हमारी ये ऑनेस्टी है, हम सेटलमेंट डीड साइन कर रहे हैं, बोर्ड में गया, ये गया, वो गया. यस मुकेश जी, आई अप्रिशिएट योर पॉइंट. मिस्टर हर्ष दित्या जी, काबरा जी, आप यू वांट टू से समथिंग, प्लीज कम फॉरवर्ड.
हाँ सर, वन ऑफ द थिंग्स जो एक काउंट हो सकता है मेरे हिसाब से इन माय लिमिटेड नॉलेज, कि आरबीआई कहता है कि एमएसएमई के जितने भी अगर बैड लोन्स होते भी हैं, सो दे शुड बी गिवन एन अपॉर्चुनिटी ऑफ रीस्ट्रक्चरिंग. एंड अगर वो रीस्ट्रक्चरिंग की अपॉर्चुनिटी ना दे करके, ओटीएस सेपरेट थिंग ऑफ कोर्स, लेकिन अगर रीस्ट्रक्चरिंग की अपॉर्चुनिटी ही नहीं दी और डायरेक्टली सीआईआरपी में उसको रीशेड कर दिया, तो आई गेस दैट कैन बी वन थिंग कि वो यहाँ ये चैलेंज हो सकता है कि दिस इज अगेन ऑब्जेक्टिव ऑफ द कोड,
ओके.
rather than going concern आपका रिकवरी के लिए आप यू आई एम ट्विस्टिंग द बिजनेस, आई फील ये एक ग्राउंड हो सकता है.
चलिए, लेट्स सी हाउ आर adjudicating authority और एनसीएलटी look into these prisons and allow such stoppage of the CIRP. But in any case, जो हम लोगों के माइंड के अंदर आया तो हमने शेयर करा. लेट्स मूव फॉरवर्ड नाउ. Section 58D provides strict time ban of 150 days, extendable once by 45 days, that too with 66% COC per hour, quite parallel to our existing CIRP prisons. 12.2. Section 58E and F govern management of affairs during CIRP under the data in possession with criteria and control model, where the board continues subject to RP supervision and COC oversight. ये आने वाले टाइम के अंदर जो व्हाट डिस्कशंस वी हैव इंटरनली एंड अदरवाइज, ये इट विल बी ए क्वाइट लेट फॉर द सक्सेस ऑफ सीआरपी. ये जो सेक्शन 58 एंड एफ है जिसके अंदर आरपी सुपरवाइज करेगा बोर्ड को या एग्जिस्टिंग मैनेजमेंट को, और एग्जिस्टिंग मैनेजमेंट कितना उसको अलाउ करेंगी या कितना उसको कोऑपरेट करेंगी, आई थिंक टाइम डेफिनेटली विल बी द रियल आंसर फॉर effective implementation of this section.
Yes, I too agree with you.
या 58E एंड 58F जो है, और उसके में फिर हमारे एडजुडिकेटिंग अथॉरिटी भी इसको सब्जेक्टिविटी के हिसाब से देखेंगे कि कितनी किसका पलड़ा भारी है. शुड वी accommodate CD or we should go with the financial creditor or COC, whatever is there. 58G deals with constitution and functioning of the COC. These are the same provisions what we have in our CIRP. Section 58H provides for the conversion of CIRP into regular CIRP in case of failure, non-cooperation, or absence of any approved plan. Section 58I permits withdrawal subject to high creditor approval. ये हमारे PSN प्रसाद जी, आपको याद होगा प्रसाद सर, जब हम लोग ये लोग इस मीटिंग में थे, PhD की मीटिंग में थे, तो आपके जो कोलीग हैं एग्जिस्टिंग, ये क्या नाम इसका, मिस्टर भारद्वाज जी, उन्होंने कैसे 15 मिनट के अंदर सारा कुछ पढ़ा दिया था. डू यू रिमेंबर?
Yes, yes.
At least I don't have that capability to recite all those provisions without seeing the screen and this thing there. I just share it with my professional colleagues. बगैर किसी स्क्रीन को देखे, बगैर किसी टेली प्रिंटर के, उन्होंने 20 मिनट के अंदर जितने भी अमेंडमेंट थे, जो मैं आपको सिर्फ अभी ये CIRP के बता रहा हूँ, उन्होंने पढ़ा दिए. एंड आई सल्यूट टू मेमोरी एंड कैलिबर ऑफ आर ऑनरेबल रिस्पेक्टेड सर मिस्टर भारद्वाज जी, बेंच 2 के अंदर जो है.
See, in fact, all the NCLT judges are versatile, having versatile capacity. Each one is unique in their own way.
Yes, sir. Yes,
Yes,
sir.
Bharadwaj, I agree with you that yes, that day could really spell out in a sequence without missing anything.
हाँ जी, हाँ जी.
Yes.
और secondly, इसके
Manoj
साथ,
ji, this was exceptional,
Yeah,
Some people
sir.
are gifted.
Yes, sir. Yes, sir. Exactly. This
Yeah,
is,
not everyone has the same stamina and the competence and the capability, right?
yes, sir. Yes, sir. I remember in in earlier again at PhD meeting when he was a guest there, तो उन्होंने पूरा का पूरा IBC एक्ट सेक्शन वाइज ऐसे ही पढ़ा दिया था 2-3 months ago. I still remember that teaching also. चलिए सर आगे चलते हैं. Section 58J governs approval of the election plan by 60% voting share and submission of to NCLT for approval akin to Section 31. सेक्शन 58 की इट सेज कि जो CIRP के रिलेवेंट चैप्टर्स हैं, ये हमारे किस एक्सटेंट तक एप्लीकेबल होंगे. Overall, if we look at overall Section 58 to 58K create a hybrid restructuring framework, combines BEAT, limited judicial intervention, continuity of business, and stronger creditor-led commercial resolution. This is, what we call it, the culmination of all these benefits therein.
Yeah. That's true.
This is all from my side as far as CIRP was concerned. Now we have to look into the relevant regulation. But remember, हम लोग तो अपने आईपा पे, और जो हम लोग अपने गवर्निंग बॉडी के मेंबर्स हैं, 28 अप्रैल लास्ट डेट है. हम लोग 28 अप्रैल की वेट नहीं करते. जो जो हमने डिस्कशन करना, जो अभी हम थोड़ा सा आगे भी डिस्कशन करेंगे, बेस्ड ऑन द रिलेवेंट रेगुलेशंस, आप इसको पहले हम उनको देख लेते हैं. आप इसको 28 अप्रैल तक पक्का भेज देना. आई जस्ट स्टॉप माय PPT here and let me move to the relevant discussion paper, bare discussion paper. Now move to discussion paper, bare discussion paper, which is there. It will be reflected in your screen. Yeah, it is reflected now. This is, you must go through this thing there. Important points I have noted down. This is our 28th April, and this is yeah. First of all, Regulation 2, which will define applicant, which will define eligible financial creditor. It's part of the code, and it will be defined in the code that who will be the applicant, who will be the eligible financial creditor. If any of among us has any idea that who will be the eligible financial creditor, what extent of applicant eligibility will be there, like default of 10 crore, 20 crore, 50 crore, and eligible financial creditor mean a person who is RBI registered banker or financial institution, he can enlighten us. At least I don't have any much idea about it. Who is expected to be the applicant means financial data belonging to a class of financial institution, what that class of financial institution shall be. तो अगर किसी को कुछ आइडिया तो he can share with us. Okay, nobody has any idea, no problem, because ये अपने आप ही IBBI कुछ टाइम पे कर देगी. Eligible financial creditor mean financial creditor of the corporate debtor notified under section so and so, meaning thereby जो 51% से ऊपर. हरीश तनेजा जी ने ज्वाइन करा तो he is quite
I've,
highly
I've
experienced.
taken him inside. Yeah.
Yeah. Okay. चलिए जी, ये पार्टिसिपेट है तो नेक्स्ट इज नोटिस ऑफ इंटेंट ऑफ इनिशिएशन ऑफ सो एंड सो. ये इसके बारे में मेरा कंसर्न है. आई रिक्वेस्ट माय फेलो प्लीज दैट दे कैन आल्सो गिव देयर कमेंट. दे सेड फॉर द डिटर्मिनेशन ऑफ डिफॉल्ट वी नीड टू लुक इनटू, से अगर किसी का डिफॉल्ट 100 करोड़ रुपए का है तो वी नीड टू लुक इनटू अमाउंट एज ऑन द लास्ट डे ऑफ द मंथ. अगर सपोज कर लो जैसे आज 22 है, आज हम अगर 22 की एप्लीकेशन डाल रहे हैं, वी नीड टू लुक दैट अमाउंट ऑफ आउटस्टैंडिंग एज ऑन 31st of March. चलिए 31st March बाई चांस ये क्लोजिंग का ईयर है, बट इफ वी वांट टू मेक एन एप्लीकेशन से इन सितंबर एनी डेट, देन वी नीड टू लुक इनटू 31st August आउटस्टैंडिंग टू see 51% default. How that will be practical possible? I don't know. For the purpose of determining the distance of value of financial debt out to the eligible financial creditor, the applicant or the authorized representative shall prepare the list of eligible financial creditors as on the last date of the month immediately preceding the month. How that will be practical possible? I have my own reservation. Others can also let me know. As far as our IU is concerned, there's nothing, no system has been developed till date whereby we are feeding live data to the IU and like that करके. तो ये कैसे practically possible होगा? Let me please give a comment on it so that we can see to the IBBI in our this thing that how we can is possible. How you can understand
तो
for a particular
बैलेंस
series
शीट बनने में 2 साल लग जाते हैं, तो पिछले महीने का तो कैसे पता?
चलिए सर, हम कहते हैं रनिंग कंपनियां हैं तो उसकी सितंबर तक बैलेंस शीट जनरली बन
एक
जाती
एक
हैं.
साल तो फिर भी लगता है सर. एंड स्टिल हाउ विल यू नो लास्ट मंथ कितने थे? इफ द एप्लीकेंट इज नॉट अ रिलेटेड पार्टी एंड नॉट हैंडिंग ग्लव्स विद द सीडी, सो अनलेस यू आर विद द सीडी, हाउ विल यू नो दैट व्हाट अदर पर्सन ओन्स?
और इसके अंदर जो होगा, जो एलिजिबिलिटी हमने जो एप्लीकेंट की बात करी थी, अब मान के चलिए ये पब्लिक सेक्टर बैंक्स जो स्पेसिफाइड एनबीएफसीज ही होंगी, रिलेटेड पार्टी का तो मतलब ही नहीं है इसके अंदर. ही दे वोंट बी एलिजिबल.
सो अभी
चलिए,
बैंक भी सीखना पड़ेगा कि एलिजिबल कौन कौन है, राइट?
नहीं
एंड
सर, जो मैं
चेक करना है सिर्फ.
नहीं सर, मैं वो कह रहा हूँ जो एक्सपेक्टेड प्रोबेबिलिटी है मैं उसकी बात कर रहा हूँ.
नहीं, आई एम ओनली सेइंग सर, लास्ट मंथ ऑफ द प्रीसीडिंग मंथ,
हाँ
राइट?
जी, हाँ
लास्ट डेट ऑफ
जी.
द preceding month,
यस, यस,
list of eligible financial creditors, so they will
यस.
also have to identify
हाँ
who
जी.
all are there, and it will be again a GLF kind of thing, I guess.
यस, यस,
It
यस,
can't
यस.
be anything else other.
यस, यस, यस. तो मेरे को इसके अंदर आप अपना जो भी आप कमेंट दें आरबीआई को, बिकॉज अल्टीमेटली ना ये वो कहते हैं ना, वो जो हर चीज़ होती है वो आरपी पे ही फॉल करती है. प्लानिंग भी वही करता है, मैनेज भी वही करता है कि ये इट रिक्वायर्स मोर क्लैरिफिकेशन. और मे बी इफ एवरीबडी यू फील कंफर्टेबल, जो लास्ट ऑडिटेड बैलेंस शीट अवेलेबल हो उसके बेस पे ये चीज़ें डिटरमाइन करी जाएं.
सर लकीली आरपी की जिम्मेदारी नहीं है ये
नहीं,
फाइनेंशियल.
लकली आरबी की जिम्मेदारी नहीं है सर. मैं
They
जब हम
will
यहाँ
get
पे
it someday. It will come to us someday.
नहीं, नो, नॉट लाइक दैट. आप मेरी
उसे
बात मत
अपॉइंट ही
समझे
आपको इसलिए किया है कि आप ये कर पाओ.
सर.
सो
नहीं, मैं सर आपको बात बताता हूँ. आज की डेट में जैसे सीआईआरपी के प्रोविजंस आए, ये जितने भी बैंक्स वाले हैं सब अपने आज जो जिनके आरपीस के टच में हैं उनको फ़ोन करके पूछ रहे हैं, बताओ सर इसको हम कैसे प्रैक्टिकल इंप्लीमेंट करें, हम इन चीज़ों को कैसे आगे बढ़ें. अब ये हमारी जो अपॉइंटमेंट होती है ना आज की डेट में वैसे नहीं होती. जो ऑडिटर की अपॉइंटमेंट वैसे नहीं होती कि बस आपने ऑडिट कर दिया, जो आपको अपॉइंट कर दिया तो आरपी का काम संभाल लो. वी हैव टू गाइड टू द बैंकर्स अ लॉट आल्सो. वी हैव टू गाइड टू आवर, आई शुडंट यूज द वर्ड प्रोस्पेक्टिव क्लाइंट, बट वी हैव टू गाइड टू द पीपल आल्सो कि कैसे होगा ये. तो दैट एज एन एडिटर हम लोग सिर्फ ऑडिट ही नहीं करते, हम लोग बैलेंस शीट में अगर कोई गलती करता है तो क्या कहते हैं आपका कंपनी, तो उसको गाइड भी करते हैं कि भैया इस प्रोविजन को ऐसे नहीं ऐसे करो. सिमिलरली हैपेंस इन आर आईबीसी वर्क आल्सो. चलिए, तो ट्राई टू नॉक अराउंड यू एंड सी इफ एनीथिंग इज देयर. मेरे माइंड में जो बात आती है वो यही आती है कि ऑडिटेड बैलेंस शीट लास्ट लेटेस्ट जो अवेलेबल है उसी के बेस पे आप करके ये चीज़ें फाइंड करो। चलिए लेट्स मूव टू पॉइंट नंबर 3। द एप्लीकेंट और हिज ऑथराइज्ड रिप्रेजेंटेटिव शैल इशू अ नोटिस ऑफ द मीटिंग टू ऑल एलिजिबल पेंशन क्रेडिटर इन सच फॉर्म एज नोटिफाइड by giving not less than 15 days time. That's okay. 15 days is, in my opinion, that is I put it in a green. It's okay. इसमें आगे कुछ टाइमलाइंस आएंगी जिसके अंदर मैं रिक्वेस्ट करूंगा कि आप डिस्कशन में कहना है कि that should be exceeded. 51% nothing more, there. I'm discussing with you जो थोड़े से controversial points है. Rest of the points you can go through and read it there. I don't want to, put time and energy. Okay. Removal and replacement of a registered professional. Same provisions are there. कि COC विद 66 करके इसको कर सकती है। तो इसमें एक मेरे माइंड के अंदर आया था कि जैसे हमारा क्या कहते हैं PG to CD केसेस के अंदर है कि आप जो आपके क्रेडिटर्स हैं RP का रिमूव कर सकते हैं। तो इसमें सेम था, CIRP वाला उन्होंने कंसेप्ट उठाया है कि वे यानी कि whomsoever new they propose they will appointed. I feel is that कि इसके अंदर ये प्रोविजन आना चाहिए कि let them remove, but as far as appointment is concerned that should be out of the panel by the panel of the IBBI. What my other colleagues feel for that?
अभी आपने खुद ही बोला था सर उनको एडवाइस करना पड़ता है, सो जो एडवाइस करेगा वो उसी को अपॉइंट करेंगे बैंक वाले।
सर मैं फेयरनेस एंगल से बात कर रहा हूँ कि
I know,
अगर हम
I
लोग
certainly agree, sir. Panel से appointment, nobody will object, so I think it's a fair.
Generally,
या
bank and they will
बिकॉज
also
मैं
go
मैं
to
सर उसका दो कारण बताता हूँ। व्हेन वी आर प्रैक्टिकली वर्किंग देयर तो वी फील लिटिल बिट हैंडीकैप्ड मेनी अ टाइम्स अगेंस्ट COC because of their power to appoint or replace us. But when they will lose this power to replace us with their choice person, then in that case they will at least
It will
think.
bring independence also in RP's working.
या दे विल थिंक एंड
Yeah.
सेकेंडली आप जब भी रिप्लेसमेंट की बात आती है तो COC अपॉइंटेड को तो NCLT बड़े इजिली रिप्लेस करने को तैयार होती है। बट व्हेन देयर अपॉइंटेड RP इज प्लेस बिफोर देम फॉर रिप्लेसमेंट दे दैट गिव्स देम लिटिल बिट ऑफ थॉट प्रोसेस। प्रसाद सर क्या कहेंगे आप?
हाँ, आप सही सही बात कहा।
सही बात कर रहे हैं, थैंक यू सर।
योर पॉइंट ऑफ ऑब्जर्वेशन इज करेक्ट।
ओके। Moratorium. There's a big difference now in the moratorium. In this case now, moratorium immediately on यानी इन्होंने ये कहा है कि moratorium के लिए आपको अलग प्रोसेस अडॉप्ट करना पड़ेगा। The election profession after obtaining approval of the not less than 51% of the voting share of the COC file an application to the adjudicating authority for declaration of moratorium in accordance with section 58G of the code. So why process of moratorium immediately on issue of the public notice is not starting? What is the logic behind it? Why a separate process under section 58G and you need to file a particular form for this purpose to start the moratorium? But anybody can enlighten me or tell me the logic for that?
Interest, sir. Interest component will not run in moratorium. Here it will continue running. If somebody wants to do outside, let them do outside. I think it's fair from that angle.
Okay. The interest component, matlab, I could not get there. I could not
Because
get
of
you.
other creditors who are not yet part of it. So there are other creditors also. You
सर
are only
मोरेटोरियम का
allowing
मेन
sir,
सर
you
एक
are
मिनट
only allowing it to eligible financial creditors.
सर
There
सर
might be other,
आप प्लीज करिए।
so there might be other creditors for whom like operational creditors, etc. Why their interest should suffer because some of you are deciding something in a closed room. So
Okay. You mean to say, I understood your point. You mean to say that when the companies are going concern, let some sort of handicap not be given to other stakeholders
who
who
are
are
not
helping.
involved in the process.
Who are not involved, who are helping in running the company. Yeah, that is there because when we are running our existing processes, we many a times face a lot of problems because we say कि हम तो क्लेम फाइल कर दो, हम तो उसके 7 का पैसे देंगे। CIRP कॉस्ट की जो कॉस्ट है वो हम दे, CIRP के अंदर जो आपके पैसे आ रहे हैं वो दे देंगे। तो उस चक्कर में वी फील लॉट ऑफ हर्डल्स इन दैट वे। बट एट द सेम टाइम जो मेरा विच आई थॉट ऑफ वाज दैट कि आप moratorium is applicable for cases also. एंड फॉर बिकॉज अगर मोरेटोरियम नहीं स्टार्ट होगा तो आपके जो लिटिगेशन है वो कंटिन्यू रहेगा। तो लेट्स सी कैसे दोनों चीज़ों में बैलेंस बनेगा।
सर अगर लिटिगेशन इतना है फिर CIIRP की जरूरत ही नहीं है, फिर सीधा CIIRP पे चलते।
ओके
तो
CIRP पे चलते
CII तभी है जब सब ठीक है। इट्स लाइक वॉलेंट्री लिक्विडेशन, सब ठीक
हैं।
Uh,
ओके,
ये तभी है, वरना
यस यस प्लीज।
प्रॉपर लिक्विडेशन।
ओके ओके ओके, हाँ जी बताइए, एनीवन एल्स वाज कमिंग आउट टू बी देयर प्लीज।
प्रसाद सर सॉरी, मैं बीच बीच में बोल देता हूँ। आई थिंक मनोज जी प्रसाद जी से पूछना
it
चाहते
is,
हैं।
no,
नहीं
no,
नहीं
we
नहीं नहीं सर,
welcome it.
नहीं, ये इस समय हम
We welcome
एक
it. We
प्लेटफॉर्म पे
welcome
हैं।
it.
मैं जैसे आप हो वैसा मैं हूँ, मैं सबसे पूछना चाहता हूँ। और देखिए होता ये है कि जब भी कोई नया प्रोविजन आता है तो मैं कोई गौर तो नहीं कि मैं हर चीज़ इन्वेस्ट कर लूंगा। ओनली थिंग इसकी थोड़ा बहुत हम ज़्यादा पढ़ लेते हैं, थोड़ा सा ज़्यादा ध्यान दे लेते हैं। तो वो लेकिन ये चीज़ें आती है एक्सपीरियंस से। आपने जिस चीज़ को एक्सपीरियंस फेल करा आपने बता दिया। और हमारी इस समय वेबिनार करने का पर्पज ही यही होता है कि हम अपनी नॉलेज एक दूसरे के साथ शेयर करें।
Collective wisdom, to gain collective wisdom.
और उसको फिर होता ही है कि जब हम शेयर करते हैं और जब प्रैक्टिकली चीज़ें करते हैं तो हम अपनी उस नॉलेज को वहां पे यूज भी कर लेते हैं। चलिए सर, लेट्स मूव टू कॉन्स्टिट्यूशन ऑफ कमिटी। द आरपी शैल कंसिडर द कमिटी एंड फाइल a report certifying the constitutional committee or to judicial within 2 days of the verification of claim। सर एग्जिस्टिंग 7 days का टाइम है CIRP के अंदर। तो मेरे ख्याल में डिस्कशन पेपर में आप कहो कि नो डाउट ये 2 दिन तो बड़े कम है। एटलीस्ट 5 दिन तो कम से कम दें, 7 दिन ना भी दें। The in my opinion, others can have their wisdom and accordingly call for that. RP shall convene the first meeting of the creditor within 3 days of the filing of the report under this regulation। सर 5 दिन का तो वैसे ही टाइम देना होता है फर्स्ट नोटिस का उनको, तो 3 दिन में पहली मीटिंग कहाँ से कॉल कर लेंगे। तो दिस आई थिंक इज इन कंट्राडिक्टरी विद ऑब्जेक्टिव ऑफ दिस थिंग देयर। बिकॉज ये जो CIRP वाले प्रिजन्स हैं इस चीज़ के डेज वगैरह वाले के, अनटिल यू टेक अ परमिशन ऑफ 48 आवर्स, सॉरी 24 आवर्स, जो 48 आवर्स जनरली आजकल बैंक्स वगैरह देते हैं। तो ये 3 डेज वाला इसके अंदर भी मेरी ये है कि 5 डेज ही रखा जाए और करके आगे बाकी सब लोग जैसा आप लोगों का ओपिनियन है तो दैट यू कैन लुक इनटू इट। टाइमलाइन सर छोटी होने में बहुत ज़्यादा परेशानी होती है हम लोगों को।
Correct, correct, correct. Reasonable timeline should be there. Timeline should be reasonable, not
और
too
सर
short.
सर जब आप सीट के उस तरफ होते थे तो आपने ये कह दिया कि हमारे लिए टाइमलाइन डायरेक्टरी नेचर है और अपने लिए वो रख लिया, सॉरी अपने लिए डायरेक्टरी रख लिया, हमारे लिए मैंडेटरी कर दिया। सर अब आप हमारे साथ बैठे हो तो आप कितना हमारा ख्याल कर रहे हो, वी आर रियली थैंकफुल फॉर दैट।
Mm.
चलिए सर। और इसमें सर एक मेरे को लगा मैनेजमेंट ड्यूरिंग द प्रोसेस, दे हैव रिटन दैट CD shall manage the affairs of the corporate debtor in a manner not prejudicial to the creditors of the corporate debtor or in a fraudulent manner। सर इसमें मेरे को व्हाट आई थॉट ऑफ इज दैट कि इसके साथ एक वर्ड और ऐड होना चाहिए, क्रेडिटर के साथ साथ कॉर्पोरेट डेटर आल्सो, नॉट प्रेजुडिशियल टू द इंटरेस्ट ऑफ द क्रेडिटर्स एंड कॉर्पोरेट डेटर। बिकॉज जब हम थोड़ा सा डीप में जाएंगे तो क्रेडिटर और कॉर्पोरेट डेटर के इंटरेस्ट में मेनी टाइम्स थोड़ा सा कंफ्लिक्टिंग इंटरेस्ट आ जाता है। तो लेट लेट मैनेजमेंट रन द दिस थिंग देयर नॉट ओनली एज पर द इंटरेस्ट ऑफ द क्रेडिटर बट एज पर द इंटरेस्ट ऑफ द कॉर्पोरेट डेटर आल्सो। व्हाट माय फेलो कलीग्स वुड लाइक टू से।
See, creditors' interest and corporate debtors' interest will be one and the same. They will not have different interests. Ultimately, it is to successfully run the business. I don't think something, the word corporate debtors' interest should also be there, because creditors' interest and corporate debtors' interest, if you really see, it is a common interest only to run the business effectively.
आई एग्री विद यू। बट व्हेन वी रन द प्रोसेस, हम लोगों ने ये भी देखा प्रोसेस रन करते करते फाइनेंशियल क्रेडिटर और OC के इंटरेस्ट के बीच में कंफ्लिक्ट आ जाता है मेनी अ टाइम। फाइनेंशियल क्रेडिटर कहता है जी मेरे को तो अब 30% का हेयर कर दो और जो OC को है उसको 70% का जो जो क्रेडिट कर दो, 90% का कर दो। तो जब हम ऑल दिस थिंग्स वी कम व्हेन
See,
वी रन द।
here what they are talking, when you read it, the corporate debtor in a manner not prejudicial to the creditors of the corporate debtor or in a fraudulent manner. Here emphasis is given for fraudulent manner more, not detriment prejudicial. That means the prejudicial and fraudulent manner are more or less put in one scale. That means there is no iota of compromise as far as the standard of work to be done.
So, corporate governance is concerned, no compromise when the word fraudulent has been used. Okay, sir.
This is my own view, small view here. See, they are saying it should not be presidential to creditors. Reason being, there is no moratorium. Since there is no moratorium, there is no problem in disposal of assets also. So that asset should not be sold so that creditors are left hanging later on. So maybe that is why this is come into picture that whatever you're doing, it should not hurt their ultimate interest.
Yeah.
Because
Okay.
moratorium is not there.
Okay. Consensus reaches to the point that this language is absolutely, okay.
It
No
doesn't
changes
affect
will be
IP's
there.
interest.
Yeah. Time will test. Okay, but at this moment, no suggestion be given to them. Okay. Let's move forward. 6 बज गए अभी ममता जी ने भी करना है. Creditors initiated insolvency process cost. सर इसके अंदर मैं ये चाहता हूँ कि यानी कि they have defined what this is there. Something of payment should also be there. Because that who will be responsible for payment, whether CD or applicant, and what is the periodicity of the payment should be there after passing of the this thing there. Because now when in CIRP process, in the proposed IBC regulation, they are making distinction of passing of the resolution and distribution among COCs in a separate way. We when we practically try to recover the amount from the this thing from the concerned stakeholder, recovery or seat of payment is really very painstaking. Let one suggestion from our side be given there, that there's some sort of saying with some sort of the supplementary subsection, sub regulation be there, whereby it should say that after passing of the CIRP cost, whosoever a responsible person shall make the payment within 15 days, 1 month, or something like that. As far as my this suggestion is concerned, at least every IP will say yes to it. But still, any contrary view, please come forward.
I think, Mr. Anand, what I view this particular part of CIRP is that here the code of conduct for the COC, that would be more vital than today what we have in CIRP, because here the whole thing is initiated by the creditors. So, be it the fees payable to the resolution professionals or any expenses incurred, how this is to be reimbursed, because it has to be done in a closure circle. And that's why a code of conduct or some guidelines in this regard, I think that would follow later on after the regulations and everything are frozen. So this is one point which I thought of. I am also learning from all of you, all my experienced senior colleagues. So this is one thing which would be very critical. And here it should be a little bit guiding so that, those are the things which must be followed while really conducting this CIIRP process.
Mr. Kabir, I must enlighten you. There is no code of conduct for COC. We have been crying for that since inception of the IBC. Nobody is listening to it, listening to our crying, as a baby, because they think among the all four stakeholders, IP is a baby and rest all are his big bosses. And first of all, secondly, you never expect that when this is a sort of process going on, that they will ever come out with a circular whereby they will say that payment of CIRP costs should be made within such a stipulated time or something like that. Because what happened is that, why I'm saying this thing is that when such sort of procedures come out to be there, then NCLT, adjudicating authority, also get teeth with them, whereby they can say that why you're not making a payment to the CIRP cost. Practically, if we see right now, we are working under financial creditors, COC members. We hardly are able to press to them for for their payment. I can tell you practically I can tell you, some of the public sector banks or maybe some private banks, they take months in payment. They take months in payment, and that is not happening with me. That is happening with many of the IPs. Some are very good. SBI is very good. PNB is very good. They make payment very promptly. But some of the banks are, they have made their system in that way that after passing of the CIRP cost, and in one of my case, what happened is that one of the bank paid quite substantial amount to me, and he stopped this payment only on the pretext that other banks are not paying.
Sir, I would be absolutely at one with you. I think all of us as resolution professionals face it. Only a little bit of silver lining. I see that this is something which is new, and maybe this may prompt the authorities to come out with the much awaited code of conduct. If there are so many things for resolution professionals, I think resolution professionals have a moral right to ask for it, yeah, to make it successful.
सर हम तो अपनी फीस की
This
बात ही
is,
नहीं कर रहे हैं,
I
हम तो
am just,
सीआरपी
I am,
कॉस्ट की
sir,
बात कर
hoping
रहे हैं.
it.
हम तो
Yes.
सीआरपी कॉस्ट की बात कर रहे हैं. एक मिनट. हाँ जी, क्या हुआ? आ जाओ आप. Yeah. I'm just concluding it in 5 minutes, please. Okay, चलिए, I have to move a little bit fast now because Mamta ji is saying that his turn is these are the timelines. ये वही हैं जो मैंने आपके साथ शेयर करी थी, और यानी कि जिसके अंदर मेरे को प्रॉब्लम थी ये वही है T16 T19 3 दिन और 2 दिन वाली. Let that be there. We have being these are the forms which you can look into it, and if you feel that some more details be required in it, then you can have a look on it. Now let me I'm just closing down my this process because being IBC student, we need to adhere to the timeline also. मेरे को जो टाइम एलोकेट हुआ था इस काम के लिए वो ऑलरेडी क्रॉस हो रहा है, तो लेट मी मूव फॉर लिटिल बिट फॉरवर्ड नाउ. आई एम रिस्पॉन्सिबल फॉर द PG to CD things also. As far as PG to CD discussion paper is concerned, it says changes. I've divided it into what are the changes in the existing regulation, what new regulations coming out of there. Existing regulation with the changes. Sorry, let me. I'm not able to share. Let me share my PPT with you first. I'm moving down to moving back to my earlier PPT. PG to CD, what proposed changes are there? The amendment bill proposes, I divided into two parts: insolvency redemption process and another on bankruptcy. Changes in existing resolutions, removal of entire moratorium for personal contest, clause 47 section 96. Everybody knows it was being abused very heavily. जब भी किसी के अगेंस्ट सरफासी प्रोसीडिंग्स होती थी तो वो अपनी 94 की एप्लीकेशन डाल के सरफासी प्रोसीडिंग्स की रिकवरी के अगेंस्ट हाल कर देता था. एंड नाउ इट्स अ वेलकम स्टेप. व्हाट आई फील इज दैट कि अब जब तक एप्लीकेशन आपकी एक्सेप्ट नहीं होगी तब तक नो मोरेटोरियम. एक्सटेंशन ऑफ एग्जामिनेशन टाइमलाइन, या दैट वाज द वेरी क्वाइट स्ट्रिंजेंट टाइमलाइन. 7 दिन का हमारे को टाइम मिलता था रिपोर्ट लेने के लिए. उसमें ऑब्जेक्शन, क्रॉस ऑब्जेक्शन, और मेनी टाइम्स तो मेरे केस में तो वो चैलेंज ही कर देता था कि मैं 7 दिन के बाद रिपोर्ट भेजता था कि भैया ये रिपोर्ट को इसी पॉइंट पे कि लेट है रिजेक्ट करा जाए. नो रीपेमेंट प्लान विद इन 21 डेज. इफ नो दिस इज द न्यू एग्जिस्टिंग प्रिजन को चेंज है. अगर कोई रीपेमेंट प्लान 21 डेज के अंदर नहीं आता तो RPS रिपोर्ट टू द AO, adjudicating authority. Adjudicating authority shall terminate this insolvency redemption process and go for that will entitle to the stakeholders under section 106 subsection 1A for bankruptcy. New regulation. What new regulations come out to be there to facilitate coordination between the RP and the PG, meaning thereby that now they say that if parallel proceedings are also going on, then a new things has come out to be there, whereby RP of PG and RP of the CIRP or CIRP shall coordinate with each other, and the underlying assets therein shall be clubbed together for CIRP RP, so that value is maximization. That is the new section 28E is coming out of there. To require submission of a comprehensive statement of assets to the extent available with the creditors, along with application under section so and so. Whenever we look into the application, we are not able to find details of the assets with them. तो ये उन्होंने कहा जी आप इसको करिए, और ये इसको रेगुलेशन 6E के अंदर, रेगुलेशन 11E के अंदर करा गया है इन दीज टू प्रीजन्स को। सिमिलरली प्रीजन्स आर इन द बैंक्रप्सी आल्सो। जो चेंजेस करे हैं एग्जिस्टिंग रेगुलेशन के अंदर, उसके अंदर ये करेंगे फाइलिंग ऑफ बैंक्रप्सी एप्लीकेशन पोस्ट टर्मिनेशन ऑफ इंसॉल्वेंसी। ये वही जो एडजुडिकेटिंग अथॉरिटी को पावर दे दी गई है कि अगर प्लान नहीं आता तो यू कैन क्लोज डाउन द इंसॉल्वेंसी रिजल्यूशन प्रोसेस एंड प्रोसीड फॉर द बैंक्रप्सी। तो उसका है रिमूवल ऑफ इंटरम मोरेटोरियम। ओके, another new section has been added, section 164E, which is parallel to PIRP proceedings, because I said today there was a confusion whether in the case of PG or to CD avoidance application can be made or not, but now they have added it in the section. Select committee so and so. New regulation that is same 28A, and facilitation of transfer of assets regulation is there. This is all from my side, and I should have shown you the PG to CD. Let me show it to you. Hardly for Mamta ji, excuse me for that, because that is also important. And let me share with you, show you these PG to CD regulations also, so that जो important points हैं हम उनको थोड़ा सा देख लेंगे. तो let me move forward.
सब PG to CD रेगुलेशन में they have said that 106 रिपोर्ट में 28A रिप्लाई करो. वो कैसे हो सकता है सर?
नहीं हो सकता,
पॉसिबल ही
बिल्कुल
नहीं.
नहीं हो सकता, नहीं हो सकता.
112 में तो हो सकता है, 106 में बिफोर COC कॉन्स्टिट्यूशन, हाउ
हाँ जी,
कैन आई टेक देयर कंसेंट?
हाँ जी, हाँ जी, बिल्कुल ठीक बात है. Sir, I'm working a little bit fast now. That is why yeah, I just PG to CD, that will be coming to on your screen in few milliseconds. Yeah. ममता जी, बी रेडी विद योर बेल्ट. आपको बारी आने वाली है आपकी. आई एम
Yes,
जस्ट हैंडिंग ओवर द बैटन टू यू. जस्ट गिव मी few, I shouldn't call minute but seconds only. Yeah, this is the insolvency process. इसके अंदर statement of assets. I would like to you have a deep look into these statement assets, and if you want, you may add and suggest to the IBBI that what other details you want in the asset. In my opinion, we have a section 79(14) and section 79(15). For section 79(14) gives the asks for the details of excluded liabilities, and 79(15) asks for the details of the excluded assets. That detail also be given in this format. This is, I thought of while analyzing these details of the assets. Facilitation of transfer of asset, you can read it, it's quite simple. It simply says that RP of the PG will coordinate with the RP of the CIRP or CIIRP, and जो assets PG को वहाँ पे transfer करने हैं, he has to take the consent of the PG has to take the consent of his COC, and then he can transfer it there. But remember, in the case of PG to CD cases, COC जो क्रेडिटर अपने एसेट्स पूल में डालता वही सीओसी का पार्ट बनता है, जो नहीं डालता वो कभी भी इसका पार्ट नहीं बनता. तो इन दैट केस इट्स क्वाइट फेयर, एंड दिस थिंग देयर, इन माय ओपिनियन नथिंग इज रिक्वायर्ड इन इट, बट
सर उसमें कंसेंट ऑफ PG इज मिसिंग, व्हिच शुड हैव बीन देयर. कंसेंट ऑफ PG हिमसेल्फ, बिकॉज प्लान तो उसका खुद का है. अगर उसी की कंसेंट नहीं होगी तो क्रेडिटर क्या करेंगे?
चलिए ठीक है सर. बैंक्रप्सी प्रोसेस प्लीज नोट इट डाउन. सेम फैसिलिटेशन और ट्रांसफर ऑफ एसेट, इसके अंदर एसेट्स की डिटेल है नहीं. फैसिलिटेशन और ट्रांसफर ऑफ एसेट ये सेम वही प्रोविजन है जो हमारा क्या नाम उसके अंदर है, PG टू CD के अंदर है. I think this is at all from my side. My due apology. I have to rush little bit for my later 5 minutes. Otherwise, ममता जी से बहुत बड़ी डांट पड़ती है मेरे को. ममता जी, I'm sorry for that. I have consumed hardly 5 minutes extra. Now I hand over my baton to Mamta ji, and she will enlighten us with
Thank you.
The 3 discussion papers. Please.
Thank you. Thank you so much. Thank you, Manuji, for your valuable time and the way you have taken us through. Without much ado, we will be always in IPA believes that we should open on time and also close on time. So it's 6:15 now. I'll just try and tell you in 15 minutes what are the changes in the three regulations that I am to delve in with. One is the inspection and investigation regulations, another is IU regulation, and the third is grievance and complaint handling procedure regulations. Now, not much that we need to talk about here, but whatever it is, I must tell you, it is quite valuable. I was talking to Manoj a while back that really the changes seems to be quite good and quite precious, if I can use that word. And kudos to IBBI for all of it. Now let me start with, I always believe in showing you the document which is actually the document, because it just helps you to get a hang of it, is what I've always felt. So let me straight away take you to IBBI Inspection and Investigation Regulations. This is something which always bothers us. So I thought, first let me take you through that. See, this is the Insolvency and Bankruptcy Board of India Inspection and Investigation Regulations. Now, before I get into it, 2-3 things that I need to tell you which has changed. Number one, we used to talk about on whom the disciplinary proceedings or the inspection and investigation will happen. Now, on the inspection investigation, the service providers has been now spoken of. Otherwise, what it used to say is that it will be on the insolvency professional entity, agency, etc. Okay, and therefore there were 3 nomenclatures that were continuously used. So what the law is now becoming is that service providers is being defined under the amended code in section 3, subsection 31A. Okay, 3 subsection 31 subclause bola jata hai for definitions. So 3/31A will talk about who are service providers. And in the words that has been otherwise used in the inspection and investigation regulations to say it will be on insolvency professional agency, information utility, all those 3 words and other words will not be used. They will be now called as service providers. So this is one change, and service providers is being defined in the amended code as 3/31A, okay, capital A. Now, the definition of service provider, of course, now that the IBC code has already found a gazette notification, so we can now, of course, refer to that definition. The service provider definition has been given as service provider. May like to hear, it's very interesting. Service providers means an insolvency professional agency, information utility, registered valuer. They have also included registered valuer, and any person falling within the category of persons notified by the central government for rendering services in relation to insolvency and bankruptcy processes under this code and is registered with the board. So that's an interesting twist and turn that has happened in the definition of service provider. Now said that, disciplinary committee also, the definition in the said regulations has also been changed. So very quickly, the one that you see in track mode is the one that is being introduced in the regulations. So disciplinary committee means I hope you're able to see. Disciplinary committee means a committee consisting of 1 or more persons as provided under subsection 1 of section 220, and provided that the persons in the disciplinary committee shall not be associated with the investigation or inspection. Here, the whole time members have been done away with. Then I was telling you service provider. Service provider shall have the same meaning as assigned in clause 31A of section 3 of the code. So let's just always understand, definitions are given in each regulation. Definition is also given in the code in section 3 and section 5. Here we are talking of section 3 subclause 31A. So in the inspection and investigation, so whenever people talk about inspection and investigation, they get confused that whether investigation word should come first and then the inspection. But let us always remember that the short word will come before and the long word will come later. So inspection and investigation. Okay, so those are the changes. And here, if you see the order to disposal of show cause notice, they have included any of the actions or directions. Why has the word directions come? They have talked about restitution. I'm sure you have understood the word restitution before also because it is there. They say that if there is any disgorgement that needs to come back, you are aware that if the provisions say that if there is something that has happened which needs to come back in the process, that where a direction has been issued by the disciplinary committee to any person to disgorge the amount, the board shall endeavor to realize the amount of disgorgement expeditiously. And whenever you file for disgorgement, every such form has been now shifted by way of a notification. Everywhere in the entire changes that is being brought out in the regulations, you will find that IBBI says that now the formats will be notified by me. It will not form a part of the regulations. Why? Because it makes it simpler. Circular and notifications can come as and when required, and changing the regulations definitely is a much larger process than coming out with a circular. So that those are the changes in the inspection and investigation regulations. Now let me just come to the changes that is proposed in information. See, this information utility regulation, it was last amended up to 13/8/2024. Very interesting changes. They have removed a lot of color coding, and they have also, interestingly, talked about financial institutions. Okay. Now, let me just quickly show you the two words that I used. They have decided some color coding to be removed. As you were aware, there was this green, yellow, red, etc. And they have started using the word financial institution. Financial institution is already defined in the IBC. Now, record of default, wherever you find form, I told you that will be format as notified by the board. So that is the normal change that has happened across all the regulations. And I told you why, because it becomes simple and it becomes more doable. Now, in the IU, this is something which is very interesting. I want to show you. See, everywhere, an information utility shall accept information in such format as notified by the board. Okay. See, here, what is the heading? The heading is authentication of default. Obviously, we are talking about authentication in a big way in IU. So they say submitted in such format as notified by the board. Okay. By a financial institution as defined in clause 14 of section 3. Previously, it was by a financial creditor, which is a bank included in the second schedule of RBI. Now that has been replaced with the words financial institution, which is much larger in gamut. You are aware that even a NBFC falls under the word financial institution. They fall under the gamut of the definition of section 3, subclause 14, clause 14. Okay. Now here, see this will give you a flare of what I was talking about. Now the record of default that is to be issued and is to be maintained, like these are, you may see the top one that will give you a fair idea of the one which is given below. Debtor does not respond even after 3. See, this remains same. The green remains the same. Okay. Debtor confirms the information of default, authenticated. So it is becoming green because the record of default is authenticated. Then they say debtor does not respond even after 3 reminders. Then this will be known as deemed to be authenticated. And the color which was previously to be given red, that has been done away with. So therefore, in the statement of default, it will be put under bracket as deemed. Debtor disputes the information of default, so it will be put as disputed, and the color yellow, etc., will have to be removed. Now, the provisions of, if you see down below also, only the green color C has been kept, and the red, etc., has been removed. So this is one change. And as I was telling you, here also see financial institution word has been introduced. And this is all about the format as notified by the board. Okay. Now, these are the changes that has happened in the IU. Now, I would just tell you about the grievance and complaint handling procedure. That's also not very many changes, but yes, let us just have a look at it. Because when you're looking straight from the regulations, you really feel very complete. Now, here, if you see, we are on the grievance and complaint handling procedure. If you recollect, as I was telling you about the service provider, here also they have written service provider shall have the same meaning as assigned in clause 31A of section 3. Then format, as I was telling you, in everywhere the format word has taken a place instead of the form. Everywhere that has happened. They say a grievance or a complaint shall be filed with the board on its dedicated portal. Okay, they have included this. And then all the forms, if you see, they have been removed from here. Why? Because they say that will be coming in by way of a circular. So if you see, this is the circular that they have planned to introduce. That's it, my friends. So thank you very much. If you have any query, we can just take that on. So it's more of an alignment, of and anyways, regulation is always the hands and legs, as I was mentioning, is more about the process, is more about minutely carrying the principles laid down in the code. So obviously forms, schedules, formats, etc. will have to find a place as it is finding a place here. Thank you.
Yeah, thank you, Mamta ji. Thanks a lot. Thank you very much. And we strictly adhere to the IBC timeline. We shall close at 6:30 precisely. Hardly 3-4 minutes are there. Anyone among us would like to add something what Mamta ji has discussed? Otherwise, we close it down.
So just one thing on a lighter note, maybe these circulars will be very hard to keep track of. Right now, they are in regulations, so we know where to find those 100
That's true.
pages at one place. But if you put them through circulars, I don't know whether that's a great idea or a bad idea. Somehow, many RPs might even miss those circulars. So regulation, I think it was a better idea. That's my take on it. But I guess
सर बात यह है भी अभी आपने देखी होगी धुरंधर मूवी आई थी तो बड़े साहब ने जो कर दिया वी हैव टू ओबे इट सर
exactly.
वी
So
हैव टू ओबे इट
don't have much to say.
it's for the convenience of IBBI but
But
at the same time we small the pillar of the whole ecosystem need to obey and abide
मैंने
by
से
what
डिस्क्लेमर पहले डाल दिया था उन्हें लाइटर नोट एंड दैट इज
नहीं सर वो एक्चुअली उनको अपनी और उनकी बात ठीक भी है ये कि इन द सेंस जो इस तरह से है क्योंकि देखिए सर उनको रेगुलेशन अमेंड करने के लिए डिस्कशन पेपर देना
और
दुनिया
Correct.
भर
एग्जैक्टली
के और चीजें
द होल
करनी
आइडिया दैट इज द
हाँ
होल
तो
आइडिया कि
वो
डिस्कशन के बाद चेंज करो अगर आप डिस्कशन ही नहीं करोगे सीधा चेंज ही कर दोगे सर्कुलर से देन व्हाट इज द मीनिंग ऑफ वी एज स्टेक होल्डर्स तो आई गेस वी आर
सर फॉर्म्स के अंदर तो मेरे ख्याल में कोई इतना ज्यादा वो वी कांट थिंक कि दैट हैज समथिंग बड़ा इंटेंसिव कोई ऐसी बात है नहीं रेगुलेशन के केस में आई कैन अंडरस्टैंड बट एज फार एज फॉर्म्स आर
लाइक फॉर्म
कंसर्न
एफए जो नया फॉर्म एफए आया है आई डोंट नो हाउ दैट विल गेट इम्प्लीमेंटेड बैंक इट्स लाइक आरपी खुद को ही बैंक गारंटी दे रहा है या कोर्ट को दे रहा है सो whom we will give that bank guarantee now FA withdrawal in 12 way so that kind of forms if it will come without discussion I don't know I mean as you said big boss ने बोला है तो मानना ही है तो मानना ही है सर
Manoj ji,
But
can
in
I
any
make
case,
a suggestion?
what your concern is that whenever we have a meeting in the days to come, we shall definitely try to, put our perspective. ये हमारे members की ये थोड़ी सी एक बात थी. तो with this
Manoj
note,
ji, I would like to make a suggestion if
yes, please,
I have
come
time.
forward, sir.
So it is not about the regulations and whatever is being proposed. It's a very general suggestion. I think the RPs are being painted with a wrong sort of brush, everywhere.
अरे वो कैमरा ठीक नहीं इधर करियो कपड़े से साफ लो. हाँ जी
So
क्या सर क्या कहा आपने दोबारा बताना प्लीज.
मैं ये कह रहा था कि RPs are being painted with a very wrong sort of brush everywhere. Whether it is the NCLTs or the NCLAT or any High Court or Supreme Court, In fact, IPs are also, they don't want to be left behind, at the time of criticizing their fellow IPs. So my suggestion to you is that, not all the IPs are rotten IPs, so to say. I'm sure, a lot of
Sir,
IPs are doing good job.
respectfully, I cut down your cord. This thing, Mr. Prasad, you being adjudicating authority, just adjudicate are this, grievance
No,
as
no,
a
sir.
ex.
No, sir. It is just a general suggestion. What I'm saying is, you as the president of IPA and the other office bearers of IPA, and including Mr. Anil Goyal and every other, person, every other IP who is running an IPA or let's say insolvency professional association or so. I think you guys should get together and try to bring home the point to the IBBI that not all RPs are alike. Not all insolvency professionals are, rotten or crooked or whatever. You should try to, I mean, there should be, you see, ultimately you have to defend. The good IPs who are doing good job, they have to defend themselves. And right now they have their back against the wall. So somebody should try and take this initiative, and something needs to be done about it. So this
Yes,
is
Mr. Jain.
what
Yeah,
my
yeah.
general suggestion is.
Yeah,
I'm
yeah,
not
yeah.
going to
Yes,
build
yes.
Mr.
that
Jain, we
concern.
appreciate your concern and suggestion also. And
Hanji, Hanji.
this has been, basically, we receive such sort of suggestions in most of our
So
webinars every day.
nothing wrong in making an attempt to build the image for insolvency professionals. That let us do it. Nothing wrong in it. Suggestion is a very good suggestion, because the image has to be built for any kind of profession. That let us see how best we can build the image of the profession and professionals doing that profession. It's a good
So,
suggestion only. Let us see.
yeah. So maybe there are, let's say, 10% IPs are not the right sort of people, or maybe 20%. But what about the others, 70, 80, 90% people? I'm sure that they are doing a
See,
good job.
as a judge, I felt every IP is well qualified and capable of delivering the job. And maybe one or two stray cases can be there, but not even 20%, as you said, even
Yeah,
lesser to that.
yeah, yeah, yeah.
So
So
don't
my,
worry. See, these
yeah,
images have to be built by every professional in his own way. That he should build first of all his own image.
yeah, yeah,
In fact, your idea is that we shall also think as an institution. We should also think.
yeah, yeah. So I think we should make use of Sir's presence also and his proximity with the NCLTs and other authorities. I think we should try to take this point across to all the authorities, whosoever are there.
Thank you, Mr.
Yes.
Jain. We shall try to bell the cat. And
Yeah.
with you,
Can I speak? Suresh Menon here.
yes, Mr. Suresh, you have all the right to speak. Please,
I'm
please.
sorry. Yeah, hi. Sorry. Hello, dear members. I'm sorry. I'm not an IP professional, but I'm definitely a lawyer come CS. So I just wanted to kind of, it is a grievance not as a professional, but it is a grievance as a home buyer where I'm stuck up with one project where I'm a general secretary also. I'm sorry, Manoj probably knows that matter most, so he knows it. But I just want to just conclude, say one small thing basically. Mr. Jain talked about RP being professional, or there are some crooked guys or some kind of, whatever he said basically. So I just want to add on that, this is a profession where a lot of home buyers are kind of really on a grievance, and they are hard-earned money stuck up. So I think there has to be a very, what you call, professional approach. When I say professional, is that it has to be forthcoming from RP that this is what we have to do, this is what we should do, this is what we suggest. please do it. Then only you'll get your plan approved. For me, my plan was filed with NCLT Delhi in 2020. Today is 2026, 6 years. It is still stuck up, and in spite of having so many IAS disposed of, only a couple of matters went to NCLAT. With a 97 percentage of the CIRP home buyers, financial creditors passing the entire plan, still we are stuck up. So I don't want to blame anybody right now, basically, but unfortunately, what I felt from the RPs are that they are not forthcoming and advising. They are doing whatever they are doing it, instead of telling that, okay, this is what we should do, this is what we should suggest, this is what we should get it over. There has to be forthcoming a professional approach. I feel that that approach is little lacking from the IPs. Maybe I'm wrong, Manoj Bhai. Sorry, I'm really sorry to kind of upfriendly saying that. But I want that IP should be. I seen that in South. I'm a South Indian basically. In South, comparatively, that professionalism is a little bit there, but in North, I find that little odd. People are kind of, oh, let it be there every month they're getting paid, so let it go, let it go. No trial to conclude the matters, no suggestion, advices, countermeasures is not forthcoming. So I would like that if that is to be addressed by Manoj Bhai and his team and to IBBI, and that's with strict, strict compliance on that matters, and also feedback from the Home Buyers Association also how their IPs are progressing. Something of feedbacks, it should be on the website where we have the right to kind of give comment to our issues and problems where IBBI can take up further. This is my general one thing. I also want to know about this recent amendment which is recently done by the government. When is it going to be notified? If it is already assented by the president, why it is not getting notified? If it is notified, probably I'm not aware of it. So Manoj bhai, sorry, this is the only thing which I wanted to say.
Yeah.
अगर मैंने कुछ गलत बोला तो sorry for the entire profession. I'm
नहीं,
really sorry for it.
Suresh, we are very happy that at least you spoke from your heart. That is the best part on your part.
So I just wanted to brief. I am a 35 years experience with the corporate life. I've been the legal head and company secretary of multiple companies, including Medanta. So I know about it. So with the background only, I'm saying now as a home buyer, I'm getting stuck up. So that's the background which I want to give it to you.
मिस्टर बैनन, इसके बारे में जो आपने बात करी, योर पेन इज नॉट ओनली नोन टू द बड़े भाई ओनली, बट इट हैज ट्रेवल्ड टू द सुप्रीम कोर्ट आल्सो. Even Supreme Court is quite very well aware of it, why these plans are stuck up. Only last week only, they have asked the NCLT and IBBI also, along with NCLT also, that give us the detail of plans submitted and why it is not being passed within stipulated time line of 45 days. Why these are stuck up for 2 to 3, 4 years. And your case of 6 years stuck up is really, really, a very sorry state of affairs. But there might be many reasoning for that. I don't want to delve into it. But I'm really concerned with your pain. Not only me, but all authorities. If we call that, if there is any class of creditors, if there is any class of stakeholders who has the biggest sympathy of the court, that might not be the result. That is the home buyer. You people have invested your lifetime savings, and you're not able to get something there.
Thank you, Manoj Bhai, for that lovely words. But yeah, sometimes I feel that even what Supreme Court also said recently is just eyewash. Had that Honorable Supreme Court been serious, they should have given NCLT at least a good office and at least full day hearing. That is also not happening at all. So I feel that even if Supreme Court asking these questions for speeding it up, but on the ground it is not. We are not seeing that at all. NCLT is sitting half day only. So how can it be completed here? So I'm just sorry that I'm just telling you from my heart. As I said to you, I'm very blunt on these kind of things.
No, I welcome your saying, and really concerned with that also. Not only me, all the persons who are attending this webinar is really concerned of the pains of not only of your home buyer but every home buyer. चलिए,
Manoj, just to clarify,
perspective.
Manoj, just to clarify, I'll just take 1 minute. It's not that I'm pointing out at you that you should lead all this initiative, right? I'm saying there are many associations. There is one in Kerala, there is one in Hyderabad, there are many others across all these states. So I think everyone should come together. All the presidents and office bearers should move together and try to build up this image building exercise for the IPs. I think it is it is high time that it is done. Thank you.
Okay, Mr. Jain.
Yeah.
Mr. Menon, as far as this thing is concerned, that when this IBC code will be notified or there, it has been clearly mentioned in the 6th April Gazette notification that it will be implemented in parts as and when required. And as far as practical procedures are concerned, IBBI wants this thing that before implementing those procedures, let relevant regulations be placed before the stakeholders, and for that they have a process that whenever they need to go for new regulations or amend the existing regulations, they go for public comments for 14 days, and minimum 14 days. After that, when they get the comment, then they culminate it and then they consider it. And we have a meeting in PSD. We have a meeting with IBBI officers only 3 days ago, whereby they discuss it, and they are probably giving 30th May date for implementation of these prisons along with the relevant regulation. Rules will be notified by the Ministry of Corporate Affairs only. This is answer to your second question. Do remember to join us tomorrow also. जो हमारे क्या कहते हैं आईपी ब्रदर्स में बिग बॉस हैं हमारे अनिल गोयल जी, he along with Mamta madam and me will take balance session for the discussion papers related to CIRP, voluntary liquidation and liquidation process at 5 tomorrow. Please join us tomorrow. Thank you very much, everybody. I'm really honored of your discussion by heart, and especially to Mr. Kabir and to Mr. Menon and Mr. R.K. Jain also, that he shared his problem with us. We shall have a meeting, physical meeting in the Delhi sometime, and try to, see the pain and the possible solution. वो हिंदी में एक ही बात आती है, who will bell the cat? So some mouse has to come forward to build the cat, maybe insolvency professional or an advocate. तो लीडर और नेता ऐसे ही बनते हैं. Thank you very much for joining us, and thank you very much for enlightening
Thank you,
us
Manoj bhai.
also
And
what
if
you're
you,
saying.
should you require any kind of assistance from me, even to go to the government, I am there to come to you. Come along.
Most welcome. Menon ji, हम मिलते हैं coming days के अंदर. We have a one-to-one meeting along with other my fellow IPs also, and then we chart out some way to move forward and think, plan how to build the cat. With this note, thanks a lot. Thank you very
Thank
much.
you.
Thank you
Thank you,
so much,
Manoj ji.
Manoj bhai.
Thank you so much.
Thanks a lot.
Thank you
Allow
so
me
much.
to conclude the meeting now. Thank you very much.
Thank you very
Thank
much.
you, Ji. Thank you so much.